Hey everyone! Today I'm reacting to a presentation by Dr. Bal Kama, a Papua New Guinean lawyer with a PhD in law from ANU. His research focuses on our constitution and how the judiciary shapes governance in PNG. Let's see what he has to say.
Colonial constitution, or go to Paris, where all the other French colonies and British colonies have gone. They said, we will do it from our own people. And with that mission, they conducted the historic consultative process. So out of that, they come up with something, a lot of significant things. Time hasn't alluded, but please see my book. But two things which I was alluding to. First, the character of the judiciary. They departed from the Australian or Anglo-Australian conception of judiciary as a passive actor who stands by and let lawyers come to them, and then they come in and they decide. If no lawyers come to them, they stand by. That's what Australian judges are doing. But the CPC said, no, we've got to depart from that. We want our judges to be infused into the system, to become stakeholders actively involved in the construction of the PNG society. Their judicial power and everyday exercise of it must be considerate of all the circumstances of the country, socio-political, economic, not only restricted to the legal black letter law analysis. Something I describe as a transformative function of the judiciary. Now, they didn't say only just by the words of it. They went further, and there are 12 provisions in the Constitution that entrench that idea. But even before that, they declared the judges to be leaders, not just judges, instruments of the justice system. All the other judges in the Pacific, Australia, New Zealand, they are seen as instruments of the justice system. Whereas PNG, the CPC, was very intentional. And I was glad Dr. Momes in his passing comments said that Ratu Mara taught the national goals and directive principles were strange. You see, those were challenges that they faced, but the CPC believed in the ingenuity, in the innovative mind that they have before them. The course from the consultation, they had a special mission. The Fijians didn't have such a broad consultation to realize the importance of the national goals and directive principles. So while they defined judges as just judges, PNG defined them as leaders. That's why you have the leadership code. They are part of that. Now, what does the leader mean in a Melanesian society? You've got to take the contextual interpretation like Judge Virgin Arakobi told us this morning. What does a leader mean? In the Melanesian society, leader means an all-encompassing function of a person to which everyone looked upon for guidance and direction and solution. Not to be secluded in their bents, away from the society, bystanderism, as some scholars have called it. Just on the side, waiting for courts to come. They have to be part of the creation, development of the society. So there are 12 functions that consolidate that. I will only touch two of them quickly. Time is catching up. Section 57. There's a presentation coming up. Go to that presentation. The voluntary powers of the court to enforce human rights. No other constitution in this region have it. Australia, New Zealand. If it was in Australia, it would be a constitutional crisis. And I'm a student of Australian constitutional law. I teach that thing as well at the university down there. They couldn't believe it. The professors at ANU couldn't believe it. Australian National University couldn't believe that we have a section 57, where judges can just pick up a phone or summon the police minister. Why is it that this is happening? You cannot go there. There will be a constitutional crisis. Our thinkers say we have to depart. Give judges their power. Section 23. Supreme Court judge can summon the speaker to convey sitting. And they have done that last year. Oh, society is going to break down. You are attacking parliamentary supremacy, they will say, in other countries. In PNG, we wave it with such pride. So what does that mean for our judges, for our judiciary? They're not the black letter law judges. They're a transformative. Time's catching up. I'll leave the other 10 functions for you to have a read. Now, Judge William Prentice in 1976 looks at all those 12 functions and say, PNG judiciary is crazy. He used the word frightening. I will skip that part. Now I'll go to the separation of powers doctrine and I'll finish. So what does all of that mean? The innovation of the CPC didn't only stop there with the judiciary. They went a bit further. Because they tailor-made the function of the judiciary, they also tailor-made, in my interpretation, the whole doctrine of separation of power. Because they created something else. 32 independent constitutional bodies, CLRC, Ombudsman, Public Prosecutor, with a clear mandate that those institutions are not subject to any authority. That's clearly spelled out in no uncertain terms. Which simply means that they do not fall under any three arms of government. They live, breathe, and give birth to outside of that framework. Because no other constitution in this region, in the Commonwealth, have something of that nature where bodies live outside of it. Australia attempted it in 1903. By 1933, the High Court ruled it as unconstitutional because they said what? It was the fourth arm, which is not what we wanted. But the CPC took it on board. So these 32 bodies, they live outside of the three arms of government. Now, where do we place them? We can say three arms of government all we want, and then you turn around and you look at these 32 bodies and you say, so where do you guys fit in? You've got to include them. So to me, they are the fourth arm. They are what I described in my book as a quadripartite model of separation of power, the fourth arm. CPC envisaged to move from the tripartite, three arms of government, to the fourth quadripartite. Now, if we elevate them, if we give the recognition and respect that they deserve, yesterday and today about the constitutional bodies not getting the support, you won't have that complaint. Because we will all recognize that they are elevated to the fourth arm. And they also need to be on the platform of a recognized arm of government, therefore getting the resources and the support. If you forget all of that, just linger on this point. Three arms of government, but what happened to the 32 other bodies? Are they bastards? Just finding their way around? Then, so the separation of powers doctrine, the constitutional story is not finished. We haven't fully appreciated the innovative framework in our Constitution. Next time, when we think about Section 99, think about the 332 bodies that are bastardized in it. So, are we a quadripartite system? That's my challenge to you. My book argues that yes, we are. My book argues that the judiciary is a transformative function. And I'd love to leave that with you. In your profession, in your lawyering, in your judicial work or any other work, think about it. Someone challenged us yesterday, I think John did in his book. He said, we're not just here to loud-hailer the Australian or the New Zealand or the British systems. Let's look deep within and unveil, find the reality of who we are. This is part of the story. Identify that the CPC created one of the most unique constitutional framework. And it is incumbent upon us to advance it. And do so without fear or favor. And do so even if it means unsettling the Australian counterparts, the British counterpart, because that's what CPC started when they say, we will not draft a constitution based on the prefabricated ideas of Canberra or in Marlborough House, in London or in Paris. Thank you. Please get the book. Thank you.
Wow. Dr. Kama really breaks down our Constitution in a way everyone can understand. His insights remind us to know our rights and the law. Share this with someone who should hear it.
Our democracy, especially when all hope is almost lost. That will now bring me to our next presenter,